Oh, hi there. Good afternoon. This is Sephton Leibbrandt. I'm an associate at Samfiru Tumarkin LLP, and thank you for all for joining us this afternoon, this morning, perhaps if you are in BC or in Alberta. We are going to be answering your questions here today for the next 30 minutes on this live Q&A. And thank you all for anybody who's tuning in at the moment. We're very, very excited to answer all your questions here. So if you have any questions, of course, you put them into the chat, and then they will pop up here on my side of things, and we'll give our shot there at answering your questions today. So again, my name is Sephton Leibbrandt. Who's joining us. I'm an associate at Samfiru Tumarkin LLP, and we are the employment lawyers. And this, of course, is our 30-minute regular Q&A session that we have to try to answer your employment questions about various matters. So, one thing I probably just want to get started off just to get the ball rolling here today is just to talk about compensation packages. Just of course at this time of year, there's a lot of terminations that are occurring, but also, of course, a lot of people getting hired on as well and receiving new contracts and things of that nature. And so, one thing that I get asked very frequently in my practice is about certain types of compensation that the company may suggest is not guaranteed compensation. For instance, bonuses or commissions, things that are variable potentially, and they may vary from year to year depending on a number of factors, including how well the company does, including the employee's own performance and things like that. I have many questions about, are these types of compensation, am I owed that as part of a severance package, or is it correct that the company is telling me that this bonus that I received for the last 5 years, well, now that I'm terminated, it's only because I'm an active employee that I get that, and I'm no longer an active employee, so I shouldn't receive that any longer. So I can tell you that the good news is that if you receive significant bonuses, or at least material bonuses, and material is usually on the order of about 10% of your average compensation from the company, then that kind of bonus or commission or things like that, those are material components of your package of compensation from your employer. And if it's the case that those are material for you, around 10% or more, of course, of your package of compensation, and you also regularly receive those from the employer, then in basically every single case, those monies must be paid to you as part of a severance package. So if the employer, for instance, is telling you that, hey, this bonus that you received, that's more than 10% or 10% of your package of comp every single year, and you receive that again for the last 5 years, 3 years, even potentially, as long as there's a history of receiving that type of material significant bonus, then absolutely at what's called common law, you are entitled to that income, no question about it, basically. And the same goes for commissions usually as well. If you receive, regular commissions obviously can be a very significant component of a package of compensation, potentially 50, 80, 100% even of one's income from the company. Those, of course, again, are material components of compensation. Likely you regularly receive those. So again, those components would have to be incorporated and considered in your package of compensation on termination, your severance package. I receive this, not infrequently. The employer tries to allege that it's only base salary. We only want to pay base salary in your severance package, and the fact is that's not permissible at common law. It needs to be every single component of your package of compensation that is material to your compensation with the company that needs to be included as part of your severance package. No question about it whatsoever. So if you have an employer that is, trying to refuse the payment of a bonus, for instance, you receive 15, 20,000 a bonus, for instance, and you receive that every single year that you were there, or a number of years recently, that is something you definitely want to reach out to the firm about. And you can, of course, contact us as well as on employmentlawyer.ca. That's our website. Reach out to us there and get information on that. The same as with respect to commission. If you have a base salary of, let's just say, $40,000, but your commissions are, 60, 70, maybe even $50,000 a year in addition to that, and the employer is trying to say, oh, well, you're being terminated now, and here's your base salary over, X amount of time. Again, that's not permissible in almost all circumstances. You would have to, receive your full package of compensation. Basically, what the common law says, you have to be made whole during the notice period, during the severance package period, or however many months that is. So, absolutely reach out to the firm about, those kind of issues. If it's a bonus, commissions, things like that, absolutely things that we can assist you with. And again, you can reach us at employmentlawyer.ca, and the link was just displayed there a moment ago in the pop-up there on your screen. So that's something I just want to talk about straight off the bat here. I see now we're getting some questions filtering in, which is wonderful. So I'm going to jump to those now. And again, if you're just joining us here, my name is Sephton Leibbrandt. I am an associate at Samfiru Tumarkin LLP, and we are the employment lawyers answering your questions here today during this 30-minute Q&A. So thank you for all for joining in this morning or this afternoon, depending on where you're located in Canada. So I received a question here from, looks like, YouTube. They're asking, I've been released from work, or I've been released by my doctor to return to work in September, but my manager and their third party refused to let me return. Is that interference with my ADA? I have been given an RTS letter. So I'm not sure if this, maybe this is referring to something potentially in the United States. Of course, we always deal with, we're based in Canada, we're typically based in Ontario, Alberta, and BC. And so those are the matters that we typically deal with. If, on this particular case, if it's a case that the employer is not allowing you to return to work, I mean, maybe that a number of issues could be why that's happening. It could be that potentially the information that's being provided is not sufficient. Basically, so everybody understands, if your case that you're on a medical leave of absence of some sort, you're returning to work. Well, the employer, of course, they don't need to know, the status of really your medical diagnosis or anything like that. That's medical information. Not entitled to that, but information that they do, of course, require is information with respect to your limitations in the workplace. How is your medical condition or whatever it is going to affect the performance of your job? How do they need to treat you, accommodate you in the workplace in order to make sure that your situation is not aggravated or made worse by any means. Of course, you're trying to return to the workplace, get back into working, and so they need to, of course, know your limitations, whatever restrictions you may have. You can only stand for a certain amount of time or sit for a certain amount of time, things of that nature. They would be entitled to that. So if the case that they're refusing to return you to the workplace, that would be the first place to look. Is the information adequate there? As long as the information is adequate, you provided that, a functional abilities form or whatever it is, outlining the nature and extent of your restrictions, that would be more than typically sufficient. And if, of course, the case is that they're still refusing and their refusal is unreasonable, absolutely reach out to us. Again, employmentlawyer.ca, and get, some firsthand assessment of your particular matter from one of our lawyers here, perhaps, even myself. Again, we're always standing by to answer those kinds of questions. So thank you for that question, Tammy. I'm going to move on here. I received another question from YouTube. Looks like Stan is asking, employer is saying that we will likely be laid off in the new year due to work shortages. I've worked for 10 years and never been laid off before. What are my rights here? So in terms of if you're referring to a layoff as in a temporary layoff, Stan, i.e. they they're alleging that they intend to recall you. It's not a permanent layoff, i.e. not a termination of your employment. If you've never been laid off before, and then you look, of course, to the contract itself. If you have an employment agreement, typically it would say in that employment agreement very clearly and specifically that they have a right to lay you off. If that is absent, or is absent from your agreement, or you do not even have a written employment agreement, then there's no right at common law to temporarily lay off an employee. That's a constructive termination of your employment, and you're owed a severance package. And for somebody who's been there, 10 years like yourself, that may be a very significant severance package. So that's, definitely a situation where you're going to want to reach out to, one of us here at Samfiru Tumarkin. Again, you can reach us at employmentlawyer.ca. And, as well, if you're just curious about how much you may be entitled to it in your severance package, presuming that, again, there's no history of layoff here, as you said, and there's nothing in your contract that permits such a layoff. Then you can go, of course, to pocketemploymentlawyer.ca, use our severance calculator there, and figure out, just on its face, potentially how much you may be entitled to, and you'll likely be surprised by how much it actually is at common law. So definitely reach out to us, Stan, in this particular circumstance. We can review the full, circumstances of your employment here. But on its face, it sounds like absolutely they're going to owe you potentially a severance package here. But just, of course, to make sure, reach out to one of our lawyers here and get a full assessment of your matter. We can look at your contract if you have one, things like that, just to make sure that that is correct, that you are entitled to a severance package in this particular circumstance. So thank you for that question. In terms of some other questions here, looking at some more people are joining us now, which is wonderful. Again, I'm Sephton Leibbrandt. I'm an associate here at Samfiru Tumarkin, and I'll be answering your questions here for the next 30 minutes, or a little bit less than that now. So thank you for everybody who's tuning in today on our live Q&A. So I see here that I'm receiving another question from, looks like, Facebook. Raz is asking, I booked some time off in January with my employer, which was approved, but now they are saying that it will be unpaid because I haven't accrued any vacation for the new year. I'm a 10-year employee and haven't had this happen before. Is this correct? What if I still have 2 weeks of time from 2024? So Raz, that is correct in part. Certainly vacation time accrues during your employment, but of course, as well, if it's the case you've been there for 10 years, and let's say in the last year, you should have at least 3 weeks of paid vacation under the ESA, and that amount accrues. It either has to be paid out to you, at the end of the year, which is usually what happens, or if they don't pay it out to you, that minimum 3 weeks of vacation for somebody who's been there for 10 years, like you have, they don't pay that out, you didn't take it, then, as you correctly point out, it's accrued from the last previous year. And so the suggestion that if it's that they're not, they're wanting you to take an unpaid vacation would seem to be wrong, would seem to be an issue there. Of course, that a lot of that is determined by what happened in the previous year. Did you have, a week, 2 weeks, 3 weeks that you didn't use in terms of your previous vacation year, and that was accrued and available to you? Then absolutely the case is that, if that is the case, then of course it's not an unpaid vacation, it's a paid vacation. You have those minimum entitlements under the Employment Standards Act, presuming that you are a provincially regulated employee, i.e. you don't work in trucking or interprovincial transport, or for a telecom, for instance. Things like that are different. They're under the Canada Labor Code, and the vacation is a little bit different there, but there would still be minimum vacation entitlements for you, even if you're a federally regulated employee, and they're basically about the same as in the ESA. So a lot of that will depend on what happened in the previous year of your employment there with respect to vacation. How much of any vacation did you take? And if it's the case, of course, that you didn't take any vacation, then you're correct that if it's not been paid out to you already, you have that vacation time accrued and available to be used there. So thank you for the question, Raz. I appreciate it. It's a good question and a useful one, especially at this time of year when many people are looking to take vacations in the holiday season. So getting a bunch of other questions rolling in now, which is wonderful. Again, if you're just joining us this afternoon, this morning, I am Sephton Leibbrandt, and I'm an associate at Samfiru Tumarkin LLP, and we are the employment lawyers answering your questions here today on this 30-minute live stream Q&A. So thank you for everybody who's joining us. I see some other questions roll in here. I see a question, looks like from YouTube, from Toman. Toman asks, my employer has been scheduling my shifts with very little time between. If I work 12 a.m. to 9 a.m., I am on the schedule again for 1 p.m. to 9 p.m. the same day. Is this legal? Well, so I mean, it may be the case, in this particular circumstance, Tom. A lot of this depends, of course, on how much break time are you receiving, and how many hours a day are you working. Of course, you cannot work more than a certain amount of time, typically, per day and per week. If it's the case, of course, that those amounts of time are in excess of what the SA prescribes. So typically, you're typically looking in terms of a day, not more than about 12 hours in a day, of course. It doesn't look like you would be at that threshold, just yet. Well, it looks like actually potentially maybe you are actually, if that's the type of shift you're working. And of course, it would also depend on the overtime. If any you're going to receive, if they're going to pay you overtime, of course, then maybe you're not too concerned about it. Of course, if you're working more than about 8 hours in a day, and of course, about on a weekly average, more than 44 hours in a week, then you're looking at an overtime entitlement there. But it sounds like potentially that there could be an issue here. We need to, of course, look at the history of what's been happening over more than just a day. Is there irregular history potentially of excess scheduling of work, so that you'll have sufficient break time between these what sound like potentially 9-hour shifts in total, or 7 to 8 hour shifts in total on the same day. So definitely want to reach out to our firm about that, see what's going on here. Maybe constructive termination situation potentially, if this has been happening on a regular basis, or they've recently changed your hours to make this happen. And so as a result of that, you may be entitled to a significant severance package depending on your circumstances. So definitely reach out to us at employmentlawyer.ca to get a firm assessment of that particular situation, because it sounds like, just on its face, that there's some issues going on there with this particular employer. And a lot of it will, of course, depend on what's the history here, how long this has been happening for. Is it very recent? Is it a drastic change? And it sounds like it is from your previous history of work. So that may well be a constructive termination where you'd be owed a severance package at common law. So thank you for that question, Toman. Getting a bunch of other questions filing or coming in, rolling in here this afternoon. At least I'm in Ontario, so this afternoon, of course, this morning. Potentially, if you're joining us from BC or Alberta. So it looks like Interstellar from YouTube asks, workplace is being sold and we are being asked to sign new contracts. It doesn't say anything about my previous years. Should I ask for this to be included? So yes, I mean, definitely on this particular matter, Interstellar, you're going to want to have you should want to have an employment lawyer look over this new contract to see potentially how it's different than your previous contract. How is it limiting your rights, which typically, of course, contracts are extremely one-sided. They favor the new employer in the workplace. So if your desire is to, of course, continue with this workplace, you definitely should get this contract reviewed by an employment lawyer. And of course, you can reach out to us at employmentlawyer.ca to get that information. But of course, just on its face, no question. So the contract, if you've been there for X or Y amount of years, seek recognition for your prior years of service. If they don't want to do that and they're trying to treat you as a brand new employee, then this may be a situation where you're looking at a termination here, termination of your employment, and the payment of a severance package to you based on your work history, things like your age or years of service and things of that nature. So before you sign anything, you're definitely going to want to get this assessed by a member of our team here at Samfiru Tumarkin, just because on its face, again, the fact is that, of course, every employment agreement, there's a great imbalance of power towards the employer. And so typically, these employment agreements, especially a new one where there may not have been an employment agreement in place before, will be very restrictive typically in terms of your rights on termination, how much money they're looking at and paying you at termination and things like that. And it may be the case that potentially there's a number of issues in the contract that may render it unenforceable, and you're owed a severance package. Or of course, again, typically if you have a sale of a business, it's either your service is inherited or the service ends and you're offered a new contract of employment potentially, and then at that point you have the option of either accepting and continuing or seeking a severance package from the employer instead. So again, definitely something you're going to want to reach out to our firm about to get full assessment of the circumstances here, your work history, whether you have previous contract or not, and of course look at this new contract that you've been provided so you can see exactly what the situation here is. So definitely reach out to our firm again at employmentlawyer.ca for that information. We're happy to answer your question in greater detail and see what your options are here moving forward. So thank you again for that question, Interstellar. Moving on here to some other questions. I see another question from YouTube. Looks like V from YouTube asks, my manager said I am not a team player and being defensive. I had 2 meetings with HR, no formal warning. Should I be concerned about termination with cause? He mentioned it might not be working. V, it sounds like there could be potential issues here that may be happening with your employment. So you understand termination with cause is a very high bar at law to reach. I mean, the employer may terminate for cause, but ultimately it's not what the employer thinks about whether it's cause or not cause. It's what the law says is cause or not cause. And as I mentioned, it's a very, very high threshold to reach here. So a lot of this would depend on your previous history with the employer. You said there's been no formal warnings, which is certainly leans to your favor that there's not cause in this circumstance, but also of course determines and depends on what exactly the full allegations are. It sounds like these are primarily performance-based allegations, and so you understand performance allegations are almost never sufficient to justify the termination of an employee with cause, almost ever. So if it's the case that they ultimately do terminate your employment with cause and attempt to pay you nothing or almost nothing or whatever it is they offer you on termination, definitely something you want to reach out to our firm about to get a full assessment of your circumstances, your years of service, age, and things like that to see what your entitlement may be at common law. And of course, if you just want, you're concerned that you may be terminated and you're curious about potentially how much you could be owed at common law in terms of your severance package, definitely fill out our severance package calculator at pocketemploymentlawyer.ca. You just fill in some brief information there. It's basically all anonymous. And you just and you get it spits out a rough figure of what you may be entitled to at common law in your severance package. Again, presuming that the employer doesn't have cause, and based on what you're telling us here, it doesn't sound like there's enough here to justify cause for termination by any means. Look, this is primarily performance-based at best. And of course, if you want to reach out to speak with a lawyer like myself, definitely contact us. Employmentlawyer.ca is where we can be reached at. All our information is there, but definitely reach out to us if it is the case that you are terminated. At the moment here, there's nothing, so you understand, immediately to do because there's certainly issues here with respect to how your employer is responding to you, but without termination of your employment, that only really at that point in time is there significant entitlements that you may well have that the employer again may be trying to deprive you of by trying to maybe make a case for cause here, trying to manufacture one in a very short period of time. So if you are terminated, absolutely reach out to us to get a full assessment of your circumstances, and we can definitely assist you, with that circumstance and the situation. We deal with those, all the time because again, very often employers simply, they allege cause without actually really understanding what cause means and the very, very high legal threshold that one has to reach to actually demonstrate that yes, this employee should be terminated for cause and potentially receive nothing in terms of a severance package. Very, very high threshold to meet there. And if you're provincially regulated employee, the ESA is where you look to for your entitlements. So again, not somebody who's interprovincial trucking or communications or potentially working at an airport or something like that. Anything that's federally regulated, as long as you're a provincially regulated employee, the threshold to actually to determine that you're entitled to absolutely nothing on your termination is even higher than it is than just saying cause or not cause. It's actually an even higher bar than that. And so in almost every single circumstance, the suggestion that a provincially regulated employee would receive absolutely nothing on termination almost never happens. Almost never happens. You're usually entitled to something if you're if you're a provincially regulated employee, and even if even if potentially if the allegations are legitimate allegations, serious allegations, potentially depending on what they are, in almost every circumstance you're entitled to at least some amount of money on your termination if you're provincially regulated. And then of course it's just generally speaking, there's a lower threshold if you're looking for what are you entitled to at common law. And in that circumstance, again, in this circumstance, performance allegations, for instance, almost never is that sufficient to deprive you of a severance package at common law. So thank you for your great question there, and a very helpful question for everybody. Thank you for everybody for joining us this afternoon. Again, I'm Sephton Leibbrandt, an associate at Samfiru Tumarkin LLP, and we're just answering your questions here on our 30-minute live stream. And we have got some more questions to get to. So thank you everybody for tuning in this afternoon and joining us. So I see some other questions rolling in here now. It looks like another question from YouTube. Lana asks, what happens if your employer decides to close the business? I've worked at my job for over 15 years, and the owners are saying we may close down in the next 6 months. So if the business is closing, as long as it's not, closing because it's bankrupt, Alana, then the fact is that, in that circumstance, you'd be entitled to a severance package. So in this particular case, 15 years of employment, it would probably be a very significant severance package. So this is definitely something you want to contact the firm about. If it is the case that, of course, your employer does close down, and at some point they write to you and say they offer you some kind of package, definitely want to get that assessed by us to make sure it's adequate. In terms of the next 6 months, so you understand, if there's no firm date that they provided, they don't say, Lana, we're going to terminate you on, let's say May the 15th of 2025. If they don't provide firm, confirmable date that you're going to be terminated, then just saying generally the next 6 months, it's not sufficient to get credit for that as a type of working notice. It's got to be a firm date, and it's got to be clear, because of course, otherwise, how are you going to go out and find another job, which of course is your obligation upon your termination? How do you go tell another employer that, oh, I can start on X or Y date, if this current employer is just telling you, oh, well, we may close down potentially in the next 6 months? That's certainly not certain enough. So if they're trying to get credit for that working notice, that's not going to work. No pun intended. And so definitely something you want to reach out to the firm about, because you'd be owed a severance package. The only thing that would change, of course, is if the business was bankrupt, for instance, and they were, under the protection of the bankruptcy legislation. Then, of course, it's a different, a different circumstance there. But if it's just they're closing down and winding up their shop, then it's a severance package that's being owed to you because your employment is being terminated. And again, after 15 years of service to these folks, definitely it's going to be a significant severance package in almost every case. But definitely want to reach out to us about that, in case look at your employment contract if you have one, see what it says there, and get a full an accurate assessment of exactly what your entitlements may be. So again, employmentlawyer.ca is where you can reach out to us, Alana, about your circumstances. Again, right now there's not too much to reach out about, just because it's more open-ended. But once you do get something firm, something saying that they're closing down and whatever they're offering you, X, Y, or Z, you definitely want to have that severance package assessed, because in basically every circumstance that we see as employment lawyers, those severance packages are grossly inadequate. They're just too low. And they don't adequately reflect what you're entitled to at common law. So please reach out to us if and when you do get something more firm from the employer saying, okay, Lana, now we're terminating your employment, and this is what we're offering you, if anything at all, of course. And we definitely can assist you with that. So thank you for that question. I'm going to move on here while we still have a little bit of time left. YouTube, Daryl asks, can the employer remove merit after a negative performance review done in bad faith? Regular duties and a vacation added up to approximately 31 weeks away from regular duties and no response after written rebuttal. So I'm not exactly sure the full circumstances of what's happening here, Daryl. But you definitely want to get it's maybe potentially a constructive termination situation that's occurring here. Not entirely sure what's happening. It sounds like you had a bad performance review, and you say it was done in bad faith. Again, there may be issues here with respect to a constructive termination. Are they changing your hours of work? Are they, is it a toxic work environment now? Are they harassing you? Things of that nature. Of course, if that's the case, you don't need to put up with that. Definitely something you want to reach out to us about to see what's happening here. Is this a constructive termination of your employment that you can allege and seek a severance package with our assistance? That's definitely something you want to reach out to us about to get a full assessment of what your circumstances are. So as you can see there at the bottom of the screen, employmentlawyer.ca, and we're of course standing by to answer your questions in that respect. But yeah, this sounds like complicated situation, something that you definitely want to get an employment lawyer's take on in terms of what's happening here. Is this a constructive dismissal of your employment, and are you owed a severance package, which of course is the main question here, right? Can you get a severance package from these folks, presuming you no longer of course wish to work for these for this particular company? And maybe it's a case in this circumstance that you absolutely can. We just need to know a little bit more about your situation and what's happening here to give you of course the the yay or the nay, the yes or the no on what you can do here going forward. So please reach out to us about that situation. So I see that that's almost all the time and almost all the questions that we have for today. I don't think I see too many more here, but thank you everybody for joining in this afternoon, this morning. If you were in BC or Alberta, great answering your questions here today again, and we will of course be streaming more future Q&A sessions. There's another one coming up, it looks like on December the 12th with my colleague Jeremy. So please again tune in for that. And I appreciate everybody who asked questions here today and everybody who tuned in. Thank you very much. And again, have a wonderful rest of your day here. And we'll of course be live again shortly, I believe in another day or so. So thanks again for joining us. Have a good day, everybody.